What really happened, EEOC and IDHR. On April 28, 2025, my mom filed a formal complaint with the EEOC, charge number 440-2025-07122, alleging sexual harassment, racial discrimination, cyberstalking, and retaliation connected to the law offices of Gunty and McCarthy and their IT vendor, Empist. On June 17, 2025, she cross-filed the same complaint with the Illinois Department of Human Rights, which assigned control number 250-623-015 and stated it could take up to 16 through 20 weeks to process, citing staffing shortages. She had to reach out to IDHR on November 18, 2025 for an update since she hadn't heard anything. She finally received a response that included the name of an investigator assigned to her case. By then, they were already past the 20-week mark, which underscored how even the timelines they set for themselves were being stretched beyond what they had acknowledged. September 30th, 2025, the EEOC reached out and told her they would confirm her appointment for October 20th in 8 days. This was supposed to be an in-person interview at the Chicago District Office. But on October 6, 2025, the EEOC abruptly canceled the interview, citing the government shutdown. It only told her the case would remain closed unless she submitted Form 5A, and that no interviews would be available until March 2026. The email also said they will not attempt to contact her again. On October 17th, 2025, my mom noticed her case was closed on the EEOC portal without ever hearing her testimony. On the EEOC's own website, it stated that interviews canceled due to the shutdown would be rescheduled. Her email, however, did not say that. She refused to accept the obstruction. She kept emailing, resubmitting materials, and documented every contradiction. When she tried responding to the cancellation email, no one answered her questions. On November 6, 2025, she sent out an email every hour from 9 a.m. to 4 p.m. No response. At 10:54 a.m., she received a prank call from Bern, New York. Bern for Bern. We have been documenting ongoing harassment referencing New York twins, airplanes, and fires. On Friday, November 14th, 2025, my mom submitted another complaint, charge number 440-2026-01188 through the EEOC's online system, documenting the EEOC's obstruction of her original complaint. Then on Monday, November 17th, 2025, she sent the EEOC another email stating that the deadline was approaching and demanding answers to her questions. Only then did she receive a phone call from Eric Lamb, investigative support assistant with the EEOC. It should not take multiple emails and the opening of another inquiry just to get a response. She then documented their phone call in an email back to Mr. Lamb, where he explained that during the shutdown, they had a skeleton crew that put out fires so no one missed their deadline. He then proceeded to schedule her interview. He said he had a 10:30 a.m. and then said, I can play a little jazz after that. My mom's appointment was scheduled for a phone interview on November 19th, 2025 at 11 a.m. CST and was told that it should take approximately 30 minutes. Before this, in an email, the EEOC wrote my mom that the next available appointments were not until March 2026. This is one of many contradictions told to my mom. Mr. Lamb also clarified in the phone conversation that once EEOC sends Form 5A, the inquiry is closed, and that my mom will not be contacted again unless that form is received. Once processed, she would be notified of the next steps, which could include further investigation, confirmation of whether charges have been filed, or a 90-day notice to sue. If this is the case, then how come in the same phone conversation when my mom mentioned to Mr. Lamb that she saw that her case was marked marked as closed online, he suggested it may be a disconnect. My mom received a Form 5A back when her interview was canceled, and she was told in writing that her case will remain closed until they receive the Form 5A back. This should never have happened, as the EEOC was trying to skip over the interview process. This is another contradiction. During their phone conversation, she told him that this situation goes beyond EEOC's scope and that she's been receiving phone calls where institutions use the names of her family members, including his name, Eric. One of my mom's brothers is also named Eric. So having an investigator with the same name continued the same pattern we've been dealing with across institutions. On November 17th, 2025, at 2:04 p.m., Mr. Lamb wrote an email to my mom and stated, "Miss Hernandez, here is my contact information. You can email docs to me here during the intake process." My mom felt this didn't seem right, as documents need to be downloaded onto the EEOC public portal. The EEOC then closed the new inquiry and reopened her original complaint. On November 20th, 2025, my mom submitted a signed Form 5A and an updated summary outline of events that totaled 21 pages. In this email, my mom stated, "I am formally requesting that the EEOC conduct its own investigation into these matters." On November 21st, 2025, my mom resubmitted the Form 5A and an updated 23-page outline. She included EEOC and IDHR in this email. Correspondence by my mom was then sent on the following dates, and not all dates may be included in this video. December 1st, 2025. My mom emailed the EEOC and IDHR to confirm they received her signed charge of discrimination Form 5A, her 23-page retaliation timeline, and all prior emails. She also asked for clarification on how to properly upload Form 5A through the EEOC portal, since her upload attempt failed. She requested written responses to her unanswered November 17th questions, confirmation of investigator assignment, and guidance on the next procedural steps. She also asked IDHR to update her protected basis to Mexican ancestry and confirm that her updated materials were added to the IDHR record. December 8th, 2025. My mom sent a formal follow-up email to the EEOC requesting confirmation that her signed charge, her 23-page retaliation timeline, and all prior emails had been properly docketed. She asked for written responses to the unanswered questions from November 17th, clarification on how to upload Form 5A, confirmation of investigator assignment, and an explanation of how her evidence was being collected and added to the case file. Because none of these procedural steps had been acknowledged since her November 17th call. She also asked the same questions she raised in her December 1st email, since neither agency had provided any procedural guidance. She followed up with IDHR as well, noting that although IDHR acknowledged receipt on December 1st, they still had not updated her protected basis to Mexican ancestry or confirmed that her updated materials were added to her file. December 10th, 2025. Fifth follow-up email reiterating all of the above and requesting written confirmation, clarification, and procedural guidance. December 11th, 2025. Sixth follow-up email documenting continued silence from both the EEOC and IDHR, again requesting written confirmation, procedural clarification, and immediate action. December 12th, 2025. The EEOC finally acknowledged receiving the 23-page retaliation timeline, but still didn't answer any of my mom's questions from the multiple emails she had already sent. Instead, they sent a series of contradictory messages, first asking whether the timeline should be included, then saying it couldn't be included, then saying it would be included with redactions. They also stated the management would decide whether to investigate or simply issue a right to sue letter, without addressing any of the procedural questions my mom had been asking since November. December 23rd, 2025 at 9:47 a.m., my mom received her first official EEOC portal notice telling her she could now access her charge online. This was the very first first time the EEOC ever mentioned uploading documents to the portal, even though my mom has been asking since November how to upload her signed charge and evidence, and none of those questions were ever answered. 1 minute later, at 9:48 a.m., she received a second email confirming that her amended charge of discrimination had been officially filed on December 23rd, 2025. December 30th, 2025 at 2:48 p.m. My mom formally requested the respondent's position statement. She never received one, and the EEOC did not respond to or acknowledge her request at any point. On December 30th, 2025, my mom uploaded a few documents to the EEOC public portal. The very next day, December 31st, 2025, her case was closed and she was immediately blocked from uploading anything further. To this day, she still cannot upload documents to the portal. Here's a video showing exactly what happens when she tries. On December 31st, 2025, at 10:26 a.m., the EEOC issued its final decision, a right to sue letter. But here's where the timing becomes impossible to ignore. On that same day, December 31st, 2025, at 10:19 a.m., the federal court issued a notice stating the following transaction was entered on 12/31/2025 at 10:19 a.m. CST and filed on 12/23/2025. This means the federal court received our motion for extension of time on December 23rd, 2025, but we did not receive the court response until December 31st, 2025, exactly 8 days later. The court stamp shows December 23rd, not December 31st. This timing aligns perfectly with the EEOC's actions. Both the EEOC and the federal court used the same two dates, December 23rd, 2025 and December 31st, 2025. Both waited exactly 8 days. And here's the most important part. My mom never received any notice of when her documentation needed to be uploaded to the EEOC public portal. The first and only notification she ever received was on December 23rd, 2025, telling her she could now download documents and access the portal. But that notification came right before Christmas Eve, Christmas Day, a federal holiday period. Minimal staffing, delayed communication. She was given no deadline, no instructions, no warning, no indication that her case would be closed. And then, just 8 days later, on December 31st, the EEOC closed her case before she ever had a meaningful opportunity to upload her evidence. The timing is not random. The alignment is not accidental. The pattern is not subtle. The EEOC and the federal court correlated their actions using the same dates, December 23rd and December 31st, and both waited exactly 8 days. On top of all of this, Enfist, the IT vendor tied to my mom's former employer, has been turning her emails with her former employer, the court, her emails from the court, her emails with the EEOC, and her emails with other institutions into internet-style images on her laptop. They are blocking her emails and attempting to distort evidence. Here is a video showing exactly what is happening. On December 31st, 2025, the same day the EEOC issued its premature right to sue letter, my mom notified both the EEOC and the Illinois Department of Human Rights of the EEOC's determination. That means IDHR was made aware of the EEOC's decision on the exact day it happened. But even with that same day notice, IDHR still did not email her any documents. Instead, they continued sending everything by physical mail, even though the deadlines they referenced required immediate action. This became especially clear with the IDHR letter dated January 22nd, 2026. Although the letter claimed she had 30 days to respond, she did not receive it until January 29th at around 2 p.m., giving her only 24 hours to act. This is not consistent with the statutory requirement of 30 days after service, and it materially interfered with her ability to exercise her rights. In her January 29th email to IDHR and the EEOC, she documented this delay and explained that receiving a 30-day deadline letter with only 1 day left is not legally or procedurally acceptable. She also copied the EEOC district director, the IDHR director, and every staff member involved, because by that point, neither agency had addressed any of the procedural failures she had raised. She reiterated that the EEOC closed her case on December 31st without investigation, without providing the employer's position statement, and without giving her any meaningful opportunity to upload evidence, and that IDHR was aware of this closure on the same day but still failed to communicate with her in a timely or accessible way. No response was given. My mom also mentioned in her January 29th, 2026 email that the EEOC portal lists Jovan Gathings as her investigator, yet she was never informed of this assignment, nor has this individual contacted her or been copied on any correspondence. Between January 9th and February 2nd, 2026, my mom sent multiple written follow-ups to the EEOC and IDHR, documenting serious procedural failures that neither agency has acknowledged or corrected. On January 9th, she responded to the EEOC's correspondence and explained that her statements did not reflect her actual experience. She documented that she was never given portal access, deadlines, instructions, or any opportunity to upload evidence after filing her charge. She also showed that investigator Eric Lamb instructed her to email documents directly to him, contradicting EEOC policy, and that he repeatedly avoided answering her procedural questions. She documented 6 unanswered follow-up emails sent between November 17th and December 11th, and she explained that the EEOC did not notify her about the public portal until December 23rd, 2025, the day before Christmas Eve, during a federal holiday period, and only 8 days before her case was closed on December 31st. She emphasized that she was never given a deadline, never warned her case would be closed, and never provided the employer's position statement, which prevented her from participating in the standard investigative processes. On January 21st, she followed up again because the EEOC still had not acknowledged her January 9th correspondence. She requested written acknowledgement, clarification of procedural failures, confirmation of next steps, supervisory review, reopening of her charge, and a full response to every question she had raised. She also repeated her request for the names and contact information of supervisors above Director Acree and Director Bennett, and asked for Director Bennett's direct email address so he could be included on all future correspondence. January 22nd through February 2nd. On January 22nd, 2026, name correlations, fire alarm incident, and IDHR letter. On January 22nd, 2026, my mom received an email from Brandy, a customer relations lead at the hotel where an employee had physically activated the red wall-mounted fire alarm inside our room. The alarm went off only in our room. No hallway alarms, no other guests present. The fire alarm incident happened on December 14th, 2025 at the Green Mill Village Hotel. The name Brandy directly mirrored Brandy Kraft, the EEOC staff member who uploaded the EEOC closure notice on December 31st, 2025. This created another unexplained name correlation. That same day, January 22nd, 2026, IDHR sent a letter confirming her charge was still cross-filed, but the letter ignored every procedural issue she had documented. It did not address the contradictory instructions, the portal access problems, the missing employer position statement, the premature case closure, or the lack of acknowledgement of her earlier emails. Because her statutory deadlines were still running, she repeated all of her requests again and asked for confirmation of receipt in a substantive response. January 23rd, 2026, the cluster of events. On January 23rd, 2026, several major events all happened on the same day. The hotel gave the burned toast explanation. They claimed the fire alarm incident in our room was triggered by burned toast. This explanation did not match the physical reality of the alarm system or the circumstances. Cherry Doak sent a letter labeled Final Response. This letter came from Minneapolis, not Chicago, and the Chicago District Director was not copied. The EEOC uploaded the January 9th letter 2 weeks late. The January 9th, 2026 reconsideration response was uploaded to the portal on January 23rd, the same day as the final response and the burned toast explanation. The January 23rd final response was never uploaded at all. It exists only in email, not in the official portal record. The meaning of the January 23rd cluster. We documented that all three events, the burned toast explanation, the letter labeled final response, and the uploading of the January 9th letter occurred on the same date. We documented that this clustering was intentional. The January 9th letter being uploaded on January 23rd aligned with the pattern of 9 family members we have been documenting throughout this process. We also documented that the combination of the final response label, the burned toast explanation, the delayed upload of the January 9th letter, and the timing of all three on January 23rd aligned with what we documented as an ambush planned for that day for 3:34 p.m. And here is the truth. We will share openly. Through divine intervention, God warned us at 3:34 a.m. God is very present. God reveals things to us. We will share more of this in later videos. February 2nd, 2026. 5th follow-up email. Major unresolved issues. On February 2nd, 2026, my mom sent her 5th follow-up email because none of her concerns had been addressed. She documented EEOC portal period. The January 9th reconsideration response was not uploaded until January 23rd, a 2-week delay. The January 23rd final response letter has never been uploaded to the portal. Cross-office involvement. Both letters were issued by Cherry Doak, an area office director in Minneapolis, not Chicago. The Chicago District Director was not copied on any correspondence. Blocked portal access exact dates. My mom began uploading documents on December 30th, 2025, after the EEOC said she could now upload evidence on December 23rd, 2025. But the very next day, on December 31st, the EEOC closed her case, and the portal instantly blocked her from uploading anything further. She had been blocked from uploading documents herself ever since. This directly contradicts the EEOC's own December 23rd instructions telling her to upload documents, communicate through the portal, and expect investigator contact, none of which were possible once the EEOC cut off her access. Investigator contradictions. The portal lists Jovan Gathings as her investigator, but she was never informed of this assignment. Jovan has never contacted her. Jovan was never copied on any correspondence by EEOC. Cyberstalking and Empist interference. She documented ongoing cyberstalking involving Empist, the IT vendor tied to her former employer. Empist is causing saved EEOC emails, court communications, other institutional documents to display as internet-style images instead of standard documents on her laptop. She has video evidence of this happening. Name correlation questions. She raised specific questions about repeated name patterns. She mentioned how at Gunty and McCarthy, she previously worked with an attorney named Sherry, who passed away many years ago. She asked whether the repeated involvement of Cherry, especially as the person issuing the final response, was intentional or symbolic. She also asked whether assigning Eric Lamb to her case was intentional, since Eric is the first name of one of her brothers. She requested written explanations for why the January 9th letter was uploaded 2 weeks late, why the January 23rd letter is still missing, why correspondence is coming from from Minneapolis, why the district director has not responded, why none of her issues have been addressed, why she remains blocked from uploading, why she was never informed of her investigator, why the EEOC told her to upload documents on December 23rd, but then blocked her, why Empist appears to be interfering with her saved EEOC correspondence. On January 27, 2026, my mom emailed the directors with both the EEOC and IDHR copied on the email and wrote, "While drafting this email, I received a mute pop-up on my device and a prank call from Dundee, New York at 7:34 p.m. from 607-292-4312. I am documenting this as well. I am also requesting clarification on whether there is any significance to the repeated appearance of the name Dunn or Dunn in relation to my case history or in general that I should be aware of." She also documented that the EEOC's actions were correlating not only with the federal court, but also with the customer service representatives she had been emailing about the fire alarm incident. January 28, 2026. Follow-up email to EEOC, IDHR, directors, and Cherry Doak. On January 28, 2026, my mom wrote to the EEOC, IDHR, the director, and Cherry Doak and stated, "Why did Miss Doak label this correspondence as final response? And under whose direction was that designation made? Additionally, is the delay in uploading this correspondence intentional? And is it being timed to correlate with any action or involvement by Judge Harjani?" She wrote this because the January 9th, 2026 reconsideration response was not uploaded to the EEOC portal until January 23rd, 2026, a 2-week delay. On January 26, 2026, Judge Harjani issued his minute order, document number 32. We had filed our motion on December 23rd, 2025, and it took until January 26, 2026 for the court to respond. The court denied our motion, even though our filing specifically requested an extension through January 9th, 2026. The January 26, 2026 federal docket entry, which included the denial of the motion for reconsideration, the court's explanation regarding the income and retirement account entries, the instruction to refile the IFP application by February 16th, 2026, the striking of the motion to unseal, and the reminder that proceeding in forma pauperis requires complete and accurate information. This email was part of her ongoing effort to document delays, unanswered questions, and procedural inconsistencies across agencies. Timetable of dates, actions, and correlations. On January 30th, 2026, the IDHR pre-investigation unit confirmed that they had timely received my mom's request. They explained that different units within IDHR handled different parts of the process and that a department charge number would eventually be assigned to her EEOC-initiated charge, but that the docketing process could take several weeks due to high volume. They also stated that both parties would be served once docketing was complete. Importantly, IDHR made it clear that they cannot access or comment on any of her questions about EEOC procedures, distancing themselves from the issues she raised about the EEOC handling of her case. They also emphasized that the 90-day federal right to sue deadline issued by the EEOC can be paused, extended, or reinstated, simply because she requested an investigation through IDHR. In other words, even though IDHR acknowledged her request, they also confirmed that her federal deadline continues to run, regardless of the delays or procedural failures she's been documenting. All of these issues remain unresolved. The EEOC and IDHR need to be investigated. Institutional complicity must be exposed.